Notice that the crowd thins out. We have on Friday afternoon. I wonder if that is by accident. It's pretty cold. Oh, that explains.
A smart politician will wait till after 5.
No. We favor access. I want to thank you all for coming on a Friday afternoon. It's been a busy week, our second full committee week. I wanted to recap a couple of the events or get a couple of the highlights. You got that? There you go.
Yeah, you saw how I had trouble with it the other day.
That's all right. Wanted to hit a couple of the highlights. Well, we all last spoke, I think it was at the AP Editors Forum. We touched on a number of topics, the budget, Medicaid, court reform. I guess I'll pick up with the last one. This week, I spoke last evening at the Supreme Court Historical Society dinner. Had some productive conversations with some members of the bench and the bar. And then just spoke this morning at the Florida Bar Board of Governors annual meeting. And I think we are engaging in a pretty productive dialogue about some of the needs of the judicial branch as well as some of the concerns of the legislative branch. I know Chairman Eisnagel had a hearing on rulemaking this week. And so we're rolling up our sleeves and working in what I hope is a very collaborative fashion to assess the challenges that the judicial branch faces, like crowded dockets, the need to make sure that we bring focused expertise to criminal appeals especially, the work that men like Sandy Delabert have done with the Innocence Commission that we were proud to fund last year is part of that conversation, and as well as ballot reform and the other issues that we've identified. So I think that's ongoing. Many of you, or some of you, have already written about the House's seeking leave of the court to intervene in the lawsuit filed by Congresswoman Brown and Congressman Diaz-Balart about the applicability of a newly added section of the Florida Constitution that impacts congressional redistricting. Much like the term limits case in the mid-90s, when the state constitution impacts something that is governed by the federal constitution generally preempts that, and because that implicates the reapportionment duties of the legislature, I believe it was important that the House be at the table for that conversation, because our main goal is to have this reapportionment process be the most open and available for public participation and transparent reapportionment process in the history of Florida. Part of making sure we fulfill that duty is to know the answer to the questions, what law applies and how does it apply, long before we get to actually trying to draw maps. So we're seeking intervener status. I expect or hope the court will grant it, but we'll wait and see. It's too soon to tell. With regard to our substantive committees, they've done some work this week. I know our HHS committee held a workshop on the state employee health insurance program. That's both an economic issue as well as one that may be impacted by PPACA and the Obamacare discussion, that those issues are interrelated. Our House State Affairs Committee began looking at pension reform, which also is an important appropriations item. And then our K-20 Competitiveness Subcommittee has begun the conversation for this year's work on teacher quality. So as our second full committee week is drawn to a close, I think we're very busy. Our committees are working, our members are working, and we're making progress on the things that we set out to. So with that, I will hand it over to you guys and take any questions.
On the intervening in the Brown Diaz-Balart lawsuit, more than 60% of Floridians spoke. You are representatives of those Floridians. Are you in that just as monitoring this, or will the House of Representatives argue against Amendments 5 and 6?
Well, first things first, the voters added language to the Florida Constitution, and even pre-election, the Florida Supreme Court said certain issues, substantive issues like these, should be postponed to be raised after the election to see if they're added. So basically, we're trying to sort of exercise our due diligence to follow up. Now that it is post-election, we want to know what our obligations and duties are as the legislative branch. The federal Constitution says that the legislature does or shall do the congressional reapportionment, and now there's a provision added to the Florida Constitution that purports to impact that same thing. Both of those obligations fall on us, and I think it's important that we be at the table to determine and get direction as to what our duties are, so we do it right. And most importantly, so that we know what the rules of the road are as Chair Gates in the Senate and Chair Weatherford in the House begin to do the public hearings. We intend to seek, hopefully, more public input than has ever been sought. It would be a shame if we allowed a failure to get a clear idea of what the legal obligations are to allow that work to be undone after almost 2 years of work.
Now, if I could just follow through that, is just when you get the opportunity, as we presented as the difficulties that the House will face in complying with 5 and 6, is that part of your argument, or are you more listening than talking?
Right now, we're just seeking intervenor status, and I think I would have to leave that to the lawyers as to what the specifics of the pleadings may contain. I think from a macro standpoint, my view is if there's federal litigation about something that is a duty to be discharged by the state legislature, we ought to be at the table just so we can be represented and understand what issues that litigation may raise and what the holdings of the federal court may be.
Are there any similarities between this and the issues that you have with the federal government in terms of the healthcare legislation and water quality standards?
It's apples and oranges in one sense. They both implicate the duties of the state government versus the federal government. But in the case of the reapportionment litigation, there's a direct provision on the federal constitution, and then now there's sort of an untested, unclear provision in the state constitution, and we just need to know what the rules of the road are, the rules of the game are before we get into it. In terms of the federal government's expansion of sovereignty into consumers' lives, telling them they have to buy health insurance, that's an unprecedented expansion of governmental powers into controlling people's choice or lack of choice in whether or not to buy a product. That's a different question. It's apples and oranges, but they both reflect that important sort of civics lesson of what's the role of the federal government and what's the role of the state government.
Do you anticipate any litigation in regard to the other redistricting amendment dealing with the legislature?
None at this time, but again, I've got to defer to the lawyers on that. My big direction is make sure we know what the rules are. We've got an important, once-in-a-decade constitutional obligation to do reapportionment. We're going to make it open. We're going to make it transparent. I know last week or the week before they rolled out the new software that I hope you all were briefed on that will enable a maximum number of really anyone who is interested to have input, propose plans, and then make sure that if we do all that work, that it's done in compliance with whatever the courts and the law say the law is, so that we can make sure that the work isn't for naught.
Well, you obviously have issues with both of those amendments. Why not go ahead and pursue those issues now, as the Supreme Court was saying?
Well, I'm not saying that won't be sought. Again, I'm just saying that's sort of up to the legal team. I think that the unanswered questions about how the language that has just been added to the Constitution will apply, because it's brand new, has been untested. So we may seek direction, and again, I've got to defer to the legal team in terms of how to go about that. But certainly we want as much certainty and clarity going into the process as possible, which is our overarching goal. Because a stitch in time saves 9. If we can determine as much of the direction as possible before we begin, that raises the likelihood that all of the work of the citizens who will participate, all of the work of the House and Senate members who will draw the maps and propose the plans and ultimately vote on them, will hopefully be done in a way that's both fully compliant with the law and will then be implemented at the end of the day.
Speaker, I understand you met yesterday with some SpaceX executives. I don't know if that is so or not. But a general question about outlook for business incentives, and particularly for space industry, with the challenges you face with the budget. That you have an outlook on how things are going to go there?
Well, I'll say this about aviation and aerospace is an industry that I think is vital to Florida. We face an extraordinary challenge of the eventual phase out of the space shuttle and a potentially loss of a highly trained, highly skilled workforce in aviation and aerospace. That's something that I and President Herodopoulos have been working on for years, because we know it's coming. There aren't any magic bullet solutions. I didn't meet with anybody from SpaceX yesterday, but I think that really is part of